own intellectual property rights. So that means if I have intellectual property right over India or patent or something in India, it is territorial only. That means in Indian territory is applicable. Other countries, I have no control over that. I cannot. The exclusive right is not available for me for any other country. So this is a sovereign state. It's very important for all the patent. And then second component is called limited period. So 20 years. After that, it doesn't become part of me. Till that time, I have exclusive right. Initially, it was 16 years actually. When initial patent act pre-independence time is involved. At that time, it was 16 years. Then after that, it has expanded to 20 years now. After 20 years, become public property. Anybody can use it. For 20 years, I have right to control that. Similarly, if you want to see about copyright, that will be different duration of time or design different. Similarly, each of the component of intellectual property have a different duration of time. So for patent, I'm talking 20 years is the time periods. On what product or process? Product means some items, process means the way to generate the items, and the best method to do that. And what are other intellectual property rights? Copyright. In case copyright, what happens? It is the artist's life plus 60 years. After death of him, for till 60 years, it will be part of property. It is his copyrights. For example, right now, if you want to do, refer to something on from say Shakespeare, a long back, it's not much more than 60 years after death. Now, there's no copyright required for that. You can directly utilize it. There's no financial control over that. So something more than 60 years of the life of the particular individual who's created it, it will not be, it will be a public domain. Anybody can use it. But before that, without his permission, he cannot use. So what case in this case, it is not product or process. It will be just 1 minute. It is. Not clear. I'm just making it. Okay. So now, if it's a trademark, so copyright is given for the claim of original intellectual creativity of a work. It can be movie, it can be song, it can be painting, it can be writing. They all comes under all the artistic creations. It comes under the copyrights. Even the formulas, even computer software program, that comes on copyright. Then next is trademark. It is another intellectual property. But only thing about that is last forever. For example, say Bata or Bajaj or Tata, these companies' trademark remain as it is till they have to keep paying money after every 10 years, and to continue that. That's all. But it will remain there. For copyright, after 60 years, it become public property, but it's not after some time that become part of public property. Trademark will remain permanently. It recognizes expressions which identify the product. So that product or that service would take Coca-Cola in America and maybe taste will be appropriate. You have to have trade.
Sir, voice is not clear, sir.
Pardon? Are you able to hear? I'm not able to hear. Is it?
Yes, sir. Yes, sir. Now it's okay.
Okay. Okay. Thank you. Okay. So design is for 10 years, and here aesthetic features like shape, configuration, pattern, or the ornaments like the gold jewelry. There are particular shapes, particular ornaments. It's more to geometrical side. It doesn't talk about utility side. So it talks about geometry. For example, certain devices, how it appear. A mobile phone will have a particular design. It is different from another mobile phones because that particular shape, the location, all things. Similarly, the Coca-Cola bottle or but these different items have a appearance different from others. They most talk about appearance. Okay, to product and process or mass production design with the industrial applicability. And next, geographical indications. This is something related to a particular geography. For example, in Tanjore, there is Tanjore doll. It is mostly known here, or Tanjore paintings, or Madurai silk, or Darjeeling tea. So they are a particular location where that location is famous for particular property items. So that they relate that anywhere else, they can use the same terminologies. Whole thing, you see, all of them are economic values because they're either brand name or creation or invention or some identification where people are going to use it for getting it intellectual developed at the same time to get some monetary benefits from that. Okay, so on the products that correspond to specific geographical location or origin or town, country like this. So to claim geographical recognition. Geographic indication is given only to organization, not individuals. So there are four major types of intellectual property. Five: patents, copyrights, trademarks, designs, and geographical indications. Is it clear so far?
Yes, sir.
Okay, good. Okay,
Yes,
now
sir.
let's see whether you can identify this or not. Before you go to patent, let's first see. So, I written patent, trademarks, industrial designs, copyright, trade secret. Trade secret means not a trademark. It is just a. It's not anything new, but something which is we are not revealing to others. Like a particular type of secret you are developing, and that is not confined. That also you can register in Indian patent, Indian IPR, Indian Patent Office. It's not patent, intellectual property office. There you can register that, and that will exclusively maintain for that. But particular ingredients you're putting, the flavor you're putting, that's called trade secret. It's nothing, may not be innovative, but something unique. So now let's see whether you can. Mickey Mouse. Which category does it belong to? Is it patent? Is it trademark? Is it industrial design? Is it a copyright? Is it trade secret? Geography indications? Yes, somebody can say. Please, I told it's interactive. No, unless interactive will not.
Sir, trademark or
Yes,
industrial design?
trademark. Mickey Mouse is a symbol only.
Yes.
The mark.
Okay.
It doesn't have a design involved to that. Scissors. Whether it is a any of these six categories. A pair of scissors.
Industrial designs.
Design.
No, it's patent. Patent. It's a patent. Different shapes of the scissors can be designed, but a scissor is a product. It's a mechanism. So it's invention. So it becomes a patent. Watch, wristwatch. Again, it's a product. Either product or process becomes patent because technology involved into that. And at the same time, different types of clocks are having, then become design. So it can have both because different clocks will have different type of appearance. But technology is patent, but the different types of clocks are designs. Copyright will have a mark like this. And if books you are reading, you have copyright. Moisture sandalwood oil. Where it is? Which category will you belong to? Yes, moisture sandalwood oil. I'm sure you have seen this. Anybody want to say?
Sir, sandalwood oil.
Yeah, it is
Geographical indication.
Yes, good. Because a particular location. Darjeeling tea also one more particular indications. The Coca-Cola bottle, it can become trade secret. The flavor will be fixed. So they'll have a mark like this they given. World Wildlife Funds, the trademark, the mark symbol, can be figures, can be design, can be any appearance. This is also another Mickey Mouse symbols. Okay, now I hope you got an idea about different types of somebody sent admission. I already admitted. Nobody is pending. Okay. Okay. So now you see these rights come as bundle. What is the meaning? Let's say iPod is just a device to hear music, right? Apple. The iPod itself, and sometimes you get a manual also how you should use it, which component is what, how to operate it, what is troubleshooting. Manual comes. In that case, the manual become what? Manual is what? One of the types I discussed. Is it a patent? Is it a design? Is it a copyright? Is it a geographic indication? What is that? Manual.
Copyright, sir?
Yes, good. Is a copyright. And similarly, this Apple symbol coming here, it becomes trademark, right? Then the particular technology is patent. It's a product or process, the patent. Now, the particular shape you see, the particular curvature, the rectangular shape, that polishing, all that particular features, geographic features, that becomes design. Now you can see same product we are getting patent, design, trademark, copyright, everything. So you can have a bundle of these things. Working mechanism patent, shape is design, name is trademark, name with trademark and copyright. So this way a bundle of rights are associated with that. Okay. Now we'll come to patent. So far you understood that what are the different types of intellectual property rights and what is the position of patent. And patent is by far the most important of all the intellectual property rights. So now just review what we discussed about patent. It is given for an invention. Invention can be a product or a process or maybe both. How do you make something or what is the product or maybe both method of making and the product itself. It should be unique. Then it is given by government for a particular country applicability. Third, the inventor, it is given to whom? The inventor, the person who invents it. Or the assignee means what? It may assign to somebody else. Okay, for example, I invent it and I give to somebody else and for a price, and then that person on my behalf also can may assign to somebody else also, or he can use it or commercialize it. And again, limited period 20 years, and as I mentioned, valid within country of plant. So certificate given to government for the particular country. So now all these rules, regulation related patent comes under Indian law of patents in the Patent Act 1970. It has been modification periodically, and but the fundamental law is Indian Patent Act 1970. There will be different rules will be there. We'll see about that afterwards. Okay. So it's a monopoly granted. Again, the new process is a new process product involving inventive step and capital industrial application. These three are very important. New, novelty should be new. Inventive step. The steps should also be unique. We'll talk about the more details in next session. And capital industrial application. It should have application also, because intellectual property comes only when there is commercial values. If there are no applications, patent because invention, so it must have applications. So this is very important. Unless all three are achieved, it cannot be a patent. We'll see more details about that. For inventive step, it may be technically it is better than previous ones, or economically it is cheaper, or environmentally is more benefit. Either ways, it should be different from existing things and capable of being made. Industrial application means industry can make it, industry can use it. Both, there are two aspects of that. Can be prepared industry and can be used by industries. And invention means, as I mentioned, is a machine, apparatus, or the articles, or the process, or how to manufacture process, or a new or useful improvement over any of the above is also a patent. Something already existing, improving over that. That also can be come to a patent. Now, once you have a patent, we have got some rights. What are the rights? Right to exploit the patent. I can use the patent. Nobody can stop me using it because I have got grant of the patent, nobody can stop me in using it. And at the same time, I have right to prevent another person to use it. If somebody uses the same thing, then I can file an infringement case against him that you are infringing my patent rights. And third, I have a right to give license to anybody. I can tell somebody else on my behalf, you can do it. I have something on different, for example, develop some product, and that are different states in India. I'll authorize different people and give license to them to use it. Patentee has power to assign rights or grant license. Similarly, right to surrender. So patentee means one who gets the patent, is given the right to surrender the patent by giving notice in prescribed manner to the controller. So I can surrender, but I don't want to continue further. Why I want to surrender? Because to maintain patent every year I have to pay money. Getting patent itself involves, filing, and it has examination. We'll talk about the stages. After getting patent also I have to keep paying money to maintain my patent. So I may think that it's not more useful. I don't want to maintain that. I can just withdraw myself. That's also possible. The right to sue infringement. The patentee has the right to institute proceedings for the infringement in the patent in the district court. No lower than district. This is minimum. District court level one can file infringement. Which are place infringement taking place? For example, my patent is I have got a patent, so it is applicable entire India. Now I find somewhere in Uttar Pradesh he is using some location that using my patent. Then I have to put a infringement case in that particular district court, because it is decided in that district court who infringement takes place. So now a patentee has or called assignee whomever assigns, he has got an agreement with a 20 years agreement, because 20 years applicable with Government of India, and he got a certificate like this, recognition of his invention, and using that. So for that they check it out with a novel. His inventive steps are there. Inventive steps there, industrial application are there. All three are satisfied or not. This is a techno-legal document. What is techno-legal? Technology, because patent is technology. It's a science. Legal means legal language, because rights are legal language. So the techno-legal documents, we'll discuss more about this. And then I can commercialize it. I or my assignee can commercialize it. This agreement with the government, and where government provides me a certificate based on novelty, inventive steps, and my applicability of my invention, which is my monopoly, and based on that I can myself commercialize, or authorize somebody to do that and get the royalty for that. So this is the patent nutshell. Now invention can be any field. It can be safety pin to satellites. It can be engineering, can be pharmaceuticals, can be bioscience, computer applications, biotechnology, nanotechnology, Ayurveda, Siddha, any field can be this patent can be granted. Just a little bit brief overview. The first patent started in 1856. 1856 is the independence time, pre-independence time. That time British law. This 1850 is the industrial revolution time. So that time all the industry, they have started this transport on railway tracks, and this coal from the different colonies of Britain, they are taken to their country, they manufactured, sent back. So they wanted to have patents that nobody else can take their rights. So that's why they introduced the patent commercialization. So 1856 they made it in the empirical court in UK, and applied to all the colonies including India. So the first patent act in India is 1856. That is mostly to protect the interest of the Britishers. That's all. British law 1852. Based on the 1856, they made it all other colonies of Britain. 1859, it was modified. Its name was called exclusive privilege. One develops some product will exclusive privilege. Again, this is mostly meant for Britishers, because there is no record of Indian getting any exclusive privilege rights at that time. Then 1872, they made Patent Design Act. Design also included into that. Then 1883, the Protection of Invention Act. 1888, then Invention and Design Act. 1911. So they progressively they make more and more modified, or more including more and more items into this. We'll not go into details into that. And then 1959, Justice Iyengar report. This is after independence. They started analyze. Iyengar Justice Anger. It is a committee that try to evaluate what is the status of patent laws in India so far and what modifications can be made. So, based on the report, 1967, the Patent Act bill was introduced in Parliament, and that one is passed in 1970. That's the Patent Act which is applicable till now. Of course, the amendments changes are there. Patent Act 70 becomes in force 72 only. It is applied. Although 70 it was started, its application started in 1972, and 1994 there are amendments are made to exclusive marketing rights. Then 1999 further amendments made. Even now 2024 also there is another amendment has made. So there's some modification changes, but basically 1970 Patent Act is still applicable with some modifications. Now, before you go further, just understand why the government want to make the patents. The basic reason of making patents is not just to give authorization for us to market it. Anybody can say, somebody can suggest me what is the objective, why government want to encourage patents so much? What is advantage for government? You are developing products, and you are getting commercial rights, and somebody else you're taking from you or not taking from you, you are getting, you can give authority and authorization or rights to somebody. This you are making money. Government, okay, taking some money for the processing. Is it the only interest of government? So processing money and all things, or is there any, what is major interest on government point of view about patent? Why they are interested for that? For that, any copyright, any intellectual property. What is so important for government point of view?
So revenue, it will generate revenue.
That is one, but more important than that,
the protection of copyright of any a design or copyright or geographical from a particular nation. I mean, to safeguard the rights of the patentee or assignee who are working in a particular nation.
But that is okay. But what government getting? You are getting benefit. Government getting money and giving facilities. But what is major benefit for government point of view? Country's point of view. There secondary benefit. Money is secondary benefit. The authorization to give something is secondary benefit. Primary benefit is that the exclusive right of the invention given to the individual, but government has got knowledge base. See, you develop something, you may market, you may go away. After death, nobody knows about it. But by patent or by any type of intellectual property, copyright and all, design, the knowledge is now preserved. So far, knowledge has been lost. With people dying, knowledge is gone. Now, because of patent only, the same knowledge is applicable till now. Very clear about that? So now they are interested to protect the knowledge. So for giving the knowledge to us, I mean to government, they are giving you a certification, they are giving authorization, you can do that till this many years. After that become property of the nation, property of the knowledge base. So most important interest for the nation to have the patent, for them any intellectual property, is to have the knowledge base. Resources, other resources may go along with the individual or the organization. Now, so they ask you to reveal everything. If you don't reveal everything, you cannot say I am violating your patent because I don't know what you made it. You clearly everything mentioned, exactly what you did, entire details. Then only you can tell you are copied from me. You say I have not revealed everything, then they'll not give patent to you in the first place. You have to reveal everything, and the cost of revelation is that you are authorized to use it. Others are not authorized; they have to pay you to use it. Only after 20 years or so, then anybody can use it. Till that time, you are right to use it. I will clear this part. To protect the knowledge base, that is most important part. Requirement of a intellectual property rights. Most important patent, because it preserves the knowledge base. For that preservation, you are revealing everything, and government is accepting it, evaluating it, and establishing it, giving a testimony for that. Now, this becomes a property for some period of time, and you can use it. You can, because you're given knowledge, you can commercialize, you can give to somebody. All that is possible. But after that, is remain property anyway. Is a public domain now. The knowledge is already available now. So, evaluation patent always they check it up. How much details your enablement are given, how details you mentioned, how many, somebody can actually work on that or not. If you're not clearly mentioned, then not grant the patent in first place. Because that means knowledge are not given fully. So we cannot hide the patent. You can say, I will not hide something, I will not tell. Then they will not give patent in the first place. It explicitly mention everything. Only then they'll give patent. Now you revealed everything. Okay? But now you can, because you revealed it, now your property now. Everybody knows it's your property. It's open revelations. So now nobody else can encroach that, because encroach, you see this I already told, but you are copying that. So you can have infringement for that. I hope this point is clear. Is it clear?
Yes, sir.
So then you also, so you get exclusive right over the invention. You get ensure commercial returns for the inventor. Then the price of the grant of monopoly is the disclosure of the invention. This is the most important. The invention disclosed at the patent office, which after expiry of the fixed period of monopoly passed into the public domain. This is the only benefit for the country. Money is very small part of that. Money for processing it, they need examiner to check it out, they need the legal procedures for maintaining infringement, all things, they need money. So that is not a money earning job for government. Mostly it is only for, mostly it is for the protecting knowledge base. Why I am telling, because these are play very important role writing our patents. Now, patent, what is patent? It adds fuel to the interest of the fire of genius. How do you know you are genius? Because the fire of genius must be revealed in terms of interest in particular items. So that is that interest, fuel of interest is patent. That is Abraham Lincoln told. And so just imagine a world without invention. We cannot live. The fan, the tube, the computers we are using, everything patented. Had there no patent, we would not have the life now. Technology will not be there any longer. Because patent is there, even the person who made it dies, still knowledge is available. So somebody else can improve over that, modify over that, everything possible. So patent plays a very, very crucial role in maintaining the technology setup of the country. So now once you get a patent, what is the advantage? Why you should, now next question, what is for us? Why we should go for patent? One thing is that patent is avoid duplication research. Somebody already done something, you don't have to duplicate it, because already knowledge already known. Keep abreast with the latest development and different fields of technology. So you'll have a patent initially, you can know what is going on now, what is trend. We'll see how to find out this. Then help industries to improve existing technology to produce cheaper and better products. Industry know what is cheaper product, what is better product based on patent only. Because your papers doesn't need full disclosure, you see. You may not disclose everything, doesn't matter. At least basic disclosure required. But patent you have to disclose everything. Then serve as an indicator of achievement in R&D institution and ability of the individual researcher. Now, the individual researcher, if you have patent, definitely sounds much stronger than number of papers, because it is much stronger, stringent, evaluation procedures, not films and fancy particular journals. They may like, they may not like, all the things. Patent has a stringent policies. So patent sounds much stronger. And once you publish it, you can't patent anymore, because already known knowledge. Maybe known, your own knowledge doesn't matter, it's already known. Patent should be new. It may not be your own knowledge also. So there are some of the patents I'll go to afterwards. And this presentation itself I have sent for copyrights. So you can do PPT also, can make copyrights protected. Okay. So any questions now? I've completed first sessions, which is about the patents. What is the introduction to patent? And what is the what are the different components of what are the basic what are the salient features of patent? And in addition to that, we also talked about what are the different other intellectual property rights and why they are so called. Any question on that, or should we go to next one? More exclusive about patent. This session are covering about the patent basics. By the way, as the organization introduced for last almost 20 years on research, and lately I have taken over to as a patent attorney. I just wanted to get more understanding about patent procedures, and there is examination available for that. You have to go through. If you're interested, we'll discuss about that. So there are very few patent agents or attorneys available all over India. So that we are authorized to patent for others also. So they give a particular agent certification for that. And before that, I had my own patents as a researcher. I have my own patents still now. My purpose is to encourage these researchers how to, because most of the patent attorneys, they're legal persons, they don't have much entry into the research, so they should make our presentation in more legal language. But so the contribution is not so much technically saying how to make it patent on what are the components, what is the technical components or what is scientific components to introduce. They're not so very clear about that. That's why I felt it will be useful for this point of view. And as I mentioned, I have got 3 patents already granted, and 1 patent is already on examination, and there are 7 designs also. I have 6 designs granted. So this is the thing. Should I go to the next presentation? Are any questions on this? Yes. Any question? Are you clear about this? I want to hear from somebody.
No, sir. Proceed, sir. Next.
Okay. So now we'll go dive into more detail about patent. We'll talk patentability. What makes it patent? What you can patent, what you cannot be patented. So we'll discuss more about that. So the criteria for patentability. How do you decide? Because what is a component of invention? How do you decide whether I can a patent or not? So there are 3 different things in the patent. One is called novelty. Utility is of course most important one. That it must have use, otherwise there is no economic values. Non-obvious. We'll discuss more. Non-obvious means what? It not be logical to a person in that skill. For example, many of you are in pharmacy. So you're finding something which is not so obvious. Okay, that anybody knows about it. It's not a particular type of domain knowledge where anybody can guess it. Already people studied it, you find something similar to that. So that is obvious. May not be obvious for me as another discipline, may be obvious for somebody in that same discipline. So it should non-obvious. It's not so obvious. It's not so expected. It should be something different than our expectation. We'll talk more details about that. What non-obviousness. First of all, it must have use. It must be utility. It must be there, and then most of the patent will have fulfilled. It's not a much problem because without utility, why will go for patent in first place? There must be need for that. Use is there, but non-obvious is one of the most difficult part. And of course, novelty. It should be new. Novelty means something unique. It's not used elsewhere. But the process of making it also should be not obvious. So unique novelty means it must have been described in a prior publication or must not have been seen by publicly used novel. We'll discuss more details about this. Now, these 3 components are the primary component of any patent. You must be new. The process of making it must not be so obvious to a person skilled in that, and it must have use. And once the 3 are achieved, then some additional things required, secondary aspects. What are they? Will come after the covering. It should be revealed completely. You must have complete revelations must be there. Without that revelation, nobody will give patent to us. In addition to that, and you fulfill all the legal condition. We'll see about that. Now let's see non-obviousness. What does meaning? Sufficiently different from what has been used prior described in prior. Non-obvious to a person having ordinary skill in the area of technology. Same technology, somebody, the examiners have the same field. So from them, it is not so obvious. The substitution of one color to another color is obvious, right? Or one change in size is obvious. They are not patentable. You cannot modify here and there a little bit, cannot be patent. This will be completely different from that. It will be more clear in the case of examples. It is a shoe. And it is another shoe. This is obvious, right? Just change the colors. So cannot be patentable. I have new shoes, cannot be patentable. Inventive means technical advanced. It must be different and improved than that. And not obvious. The advancement not so obvious. You can say, okay, sodium chloride in putting instead of potassium chloride you can put. No, this is quite obvious. Sodium, potassium both belong to the same group in periodic table. So both will follow anyway. So same process then you follow alkalization. So why you need that? Similarly, instead of this particular, one product, I can say another product. Let's say, or instead of this common brick, I will fly as brick. It's quite obvious. Both have a similar tensile property and compressive property. So it's okay, obvious. Anybody can see that. So we cannot have obvious to the people expert in the particular field. Must be advanced. How do you know advanced? You have to compare the prior art. Prior means the art existing before that. And all the prior arts, and you have to combine them. Prior arts can be in terms of earlier existing, or it can be knowledge base. Obvious. For example, some of the things are conceptually clear. We don't need an example for that. Just a knowledge itself says that. So these are different prior arts, and it can be available in terms of patents, other patents, or books, or trade or professional journals. They will publish something, or advertise in catalogs, or government documents, or illustrations, public illustrations. All of them become prior art. We'll talk more about that when drafting patent concept. But right now, just understand anything existing in public domain known to everybody is called prior art. So you have to, our patent application or our invention must be different from the prior art, significantly different. It's not just obvious from that. It is different for sure, but not obvious from that. So novelty is important and non-obvious is also important, not obviously different. We'll see that more closely. So as I mentioned, additional criteria with that is patentable. There are some items invention, but it's not patentable. Although the invention, but patent will not grant for that. What are the items? We'll talk in a few minutes. As per Indian Patent Act 1970, there are some items mentioned which are not included in patent applications. We'll see why they are and what are they. And then, so this can be product, process, and apparatus. But at the same time, it must in the Section 3 and Section 4 of the Indian Patent Act 1970, they mention a list of the things which cannot be patented. Although it can be invention, but can be product, can be process, apparatus, but cannot be patented. We'll see about that. And in addition to that, you should have specification, very clear specification, the best way to perform it. How do you perform it the best way? That method should be very detailed mentioned for enablement, where anybody can use that. There is a specification. So details should be mentioned. And in that you have a claim. What is specific about you? That your claim. That is your right. And nobody, based on claim, will decide somebody's patent is infringed or not. But claim based on specification or detailed description, based on that, my product have this particular salient features which are unique to others. This or my process, this type of procedures unique to others. That is what my claim. And how I did it, what an analyzer did, those explanation of that or database for that becomes specifications. So this also very complete specification required for any patent grant. Specification not complete, not illustrative, and not sufficient detail, then it cannot be patented. So in addition to non-obviousness, utility, and novelty, patentability also should be matching with the patentable invention list, or should not be non-patentable inventions, and should have met all the specification requirement. A specification means specified not detailed description, best method, capable of enabling person skill to. I mentioned that the most important purpose of patent is that the knowledge base. So if you don't give specification, knowledge base is not given. So that's why it's very important. But the best way to accomplish it and detailed method given. So all these 5 forms the actual. If all the 5 are made properly, then your patent will be surely granted. So how do you know? So this is what we are talking about. It's not a guesswork. Very clearly, just like paper publications, it's very clearly you can make a paper granted if all the 5 components intact. We'll see how to make sure that. So now we talked about non-patentable, whether patentable or not. So there are some things, inventions, but not patentable. What are they? In Section 3 and Section 4, they're mentioned. Some of them are writing, not details. Section 3 will have frivolous inventions, like which is against in natural law. Like time machine with more than 100% performance, not possible, right? always output will, efficiency is less than 1. So can 100% performance. No energy spent, but I getting more than more energy, not possible. So this type of frivolous, because they've highlighted the fundamental laws, perpetual motion machine. So this type of products which is not scientific, so that cannot be patentable because this is not valid. 3b, commercial exploitation or primary use of the invention which could be contrary to public order and morality. That means you are preparing a machine to steal property of others. Even it is an invention, but its purpose is what? Burglary, gambling, or biological warfare. This type of publicly harmful or harmful to morality, doing wrong activities, even invention will not be patentable. So you all know the purpose, because this will against the purpose, because it go against the ethics of the country, or it causes serious prejudice to the health of human, animals, plant life, or environment. Either human being, animal, or plant, or environment should not be affected by that. So a method or device to adulterations is the same thing, or destruction of plants and animals, destroy environment. So even if make a method cannot be patentable, because that go against the public requirements. Government can encourage that. Government cannot encourage such type of activities, Then C and D. C is about discovery of scientific principles of formulation of discovery of any living thing, non-living substance occurring in nature, new form, property, or use of a known process, machine, apparatus. What does it mean? That means, for example, I have got a alarm clock. Now with alarm clock attached, when the alarm rings, it triggers, and one water jet will fall on my eyes, so that I can get up. After 2 times ring, then after if you don't get up, then I'll attach some water pump. It pressurize that, so pump will come, water fall on my eyes, so I can get up. So this cannot be patented because water pump is existing, alarm clock is existing. You just combine them together. So any mixing of 2 components cannot be patentable. It should be inventive stage not made. You know, nothing new in that. Okay, so mere discovery of something, similarly one scientific principle, another principle derived from that can be patentable. Or a formulation, no formula or principle patent, because there is no product or process. It should be industrially applicable. You can use some laws, Newton's law, or Dalton's law, or whatever. You cannot make those things patents because there is a formulation only. This can be copyright, not patent. Discovering something cannot be patent. I discovered something cannot patent. It can be copyright. But new form developing, mixing together like a polymer, cannot be patent. You have to monomer combine together, make a polymer, cannot be patent. So because admixing them. Similarly, any property, you change the properties. Means something has one property, another use. Some product, for example, you are using some drugs. It has got one property they discovered for using for that. Now you find this is also applicable for something else, like penicillin is applicable to something else to discover. So that cannot be patented because product and process both are same, cannot be patentable. Okay, so either product, process, or apparatus, any of them has to change. Same thing cannot use different ways, or any mixture of either mechanical mixture, chemical mixture, they are not patentable because there are no inventive steps involved into that. So new use of a drug or any mixtures discovering law or plant or animals or gas or mineral, this cannot be patentable. Composition obtained by mere admixture or its preparation process. A detergent considers active ingredients and inert carriers. So no role of functional activities. So if you put inert carrier, put instead of that some other pigment you're adding, or some other inert materials for giving smoothness for that, or some type of reflection, all things adding there, they are not going to contribute active ingredients. If efficiency is not improving drastically, so cannot be patented. Slight modification not possible. Technically should be advanced, or economically should be better. Similar mere arrangement, rearrangement, or duplication of known device. Each functioning independently of other. Pocket, similar thing at bucket fitted with a torch, so that you can see the light and carry the water. Or umbrella with a fan, so that sunlight is there, at the same time fan is also diffusing the heat. So they are all just already existing knowledge. Combined together cannot be patent. Should be innovative. Should be novel. This is novel for sure, but inventive should be there. These are now common sense. This is important. New agri horticulture methods. How to cultivate algae, how to cultivate mushrooms, or spirulina. All these things you cannot patent it. The process. Now this is a natural process. Methods cannot be patented. or method of dissections, method of certain operation cannot be patented. Why so? Anybody can tell me why this cannot be patented? Someone develop a new method of cultivation, it cannot be patented. Why? It's a process only. Like you are making the hydroponic or aquaponic. So many methods are developed. Now you can commence a method, develop something. Can you patent it? You cannot. As per 3H, you cannot patent it. Why? Please, anybody can guess? Yes, please. Whatever comes to mind, you please share. Okay, most important thing is that if you develop a particular method, you patent it, then nobody else can use it, right? Then what is the benefit for the country? So new method for helping people, like COVID vaccine, you cannot patent it because you keep it in your hands. Now all the people are suffering. You will not give it. You charge money. We'll come to that. That is also one part of that. The drugs can be patented, but the method of some type of treatment cannot be patented. We'll talk about that drugs and methods more details. So similarly, particular plant, if develop better methods, production of improved soil or composting or the equipment, specific equipment which commonly can be used by common people, that cannot be patented because this is supposed to be public knowledge. People should know. You can write down and make copyrights for that, but the method cannot be patented. Because if you do that, then you are excluding people from using that method for benefits. It's a common use, common applications. But yes, agriculture equipment can be patented. Some way to cut these trees, or plug the coconut, all different type of machineries, or sprinkling the water, whatever called, or irrigation. All the methods can be patentable. Or GMO is patentable. Okay, genetically modified organism is patentable because they are modified. It's not natural. We changed it. But natural process, natural plants, even any blend of that naturally cannot be patentable. Any process or medicinal, see this I'm talking, medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, and other treatments of human beings or animals for curing or increase the product's value can be patented. That means people exploit it. A particular operation method for dissection or method for treatment or prophylactic. So this part, if you patent it, then because of the commercialization, you will not get benefits. So that's why they are not acceptable. But yes, surgical processes or vaccination, blood transfusion can be patented. But one more thing here, there will be something about this patent. This type of patent government allows, but there is something about government checks them up. It should not be too much cost where people are not getting benefited. In that case, somebody else can apply against your patent and get a compulsory licensing that you are patenting and exploiting, people not get benefited. The government only wants people to benefit it. So possible that you can patent it, but if you don't, you make the cost very high, people are not able to access it. You develop a new cancer drug. You can drug can be patented, but now you charge too much, so only richer people can use it. In that case, government, because government is certificate, it has right to take over. Government a right to take over and give to somebody else. Anybody can apply. These people are exploiting these things commercially. People not get benefited. Take it over. Somebody can mute it, please. Organizer, please. Somebody is unmuted. Noise coming. Okay. Then similarly, skill of performing mental games like the method of solving crosswords, chess, or the Rubik's cube, all the method solving mathematical problems. These methods can be patentable. Organizers, please see that somebody is unmuted because your recording is also coming improperly.
Lavanya. Hello, Lavanya. Miss Lavanya.
Or you can unmute first. Whenever you want to talk, you can unmute. No, unmute and talk. Please mute. Okay, thank you. Okay, so presentation informations that also cannot be patented because media recordings, for example, PPT, they are copyrights, not patent. Then, so now some of the basic types, some more are there, like, but they are basic types. So in addition to that, we have literary, dramatic, musical, aesthetic. They're not patentable because of the copyrights. Topography of IC, like chips they're using, using the topography of the chips, integrated circuits. So that cannot be patentable. Traditional knowledge can be patentable because people are already using it. You might have heard about the turmeric using for treatment. So that can be patentable. Already people are using for hundreds of years. Inventions are related to atomic energy. This is section 4. And related to atomic energy can be patentable because it is security threat for the country. So country can take over that patent. They're not allowed to patent. So these are the different things. We are non-patentable. Invention for sure, but cannot be patented. Okay. So now you'll see. Just check it up whether you can know whether patentable or not. Check the patentability. A device method committing the theft or burglary or biological warfare. You all know that it's not patentable. Like somebody stealing, somebody coming and stealing and going, you cannot patent it. Next. A cigarette having a particular filters, flavored cheese filter cigarette. So filter will enough, don't filter enough tar and nicotine. So you're adding cheese for efficiency. Plus you have your own flavor, hard cheese you're using. Can be patented? You get the cheese into small pieces, mix with 1/3 of the charcoal, and charcoal absorb the cheese oil and the filters become not odorous. Odor will not come in the cigarette. Can you patent it or not? No, because you see, cigarette smoking itself is bad. So by this you are encouraging cigarette with this. So not patentable. Is exploitation of inventions. Similarly, you have another cigarette holder, contractual band ring, where you can hang the cigarettes. Again, same thing. You're using something for cigarettes. Cigarette is not helpful. So this also can be patented. You have a butter stick, uniform flow of butter. Stick is there, like a gum stick, uniform flow of butter, and control melting due to the frictional heat generated by this butter and rubbed with the bread. If you rub now, the friction based on that uniform distributed. Can it be patented? Butter stick? No, because the technology, the inventive step is not there. Any butter will melt because of heat. So what is the big deal in that? So it's obvious by anybody a butter rub it that due to friction will melt. So it's novelty, but it's not inventive steps. So mere arrangement. Similarly, you have a helmet where you have something to drink water, breathe, controlling the water, different type of liquids you have, water and some juice and all things. You can have control in the helmet itself to it. Again, helmet wear with all multiple facilities. Again, cannot be patented. Again, arrangements. Not all are independent things, but combined together. So they know. So if you're combining this, should have a synergistic effect, which is more than individual effects. Then it's possible. For example, we have got a patent on the, got one patent for this mosquito repellent coil, natural. Ingredients are all, which are known to people, different types of ingredients, which are automatically repelling the mosquitoes. So combined together, the question came, how can you patent it? Because already existing. We showed that the combination is 10 times more than individual ones. It is not expected, the combination. The way of combining them, the formulating them is unique. So inventive step shows that the type of rearrangement, no, it's not just mixing of that. We are able to bring out a product which is having more efficiency than expected from all the ingredients put together. So if the synergy, you can bring it back. Synergy means what? 1 plus 1 is 11, not 2. So it increases more than expected. Or symphony. In that case, can be patentable, even the known ingredients, because you are not expecting that. But in this case, expected, so it cannot be. So that you have to justify. Similarly, you want to put the eye drop. So put a spectacle with a magnifying lens and put a funnel and put this. The eyes will be expanded. It directly will come to the eyes. Again, it cannot be patented because again mixing together. Because funnel doing funnel function, and this lens doing its own function and with their function. They will just combine together in particular way. So the arrangement, rearrangements. There's nothing uniqueness in that. Similarly, an umbrella with a torch. Again, not patentable. Similarly, spoon where to control eating. Red and green signals regulate eating quantity. After a few times, color changes. Sir, I've eaten too much. I'll get control. Other I'll be obese. So this type of eating controller you can have with a spoon itself. It's a new invention, novelty. But again, the method used is simple, is expected because it is function each its own function. The signal is processed in the same way, so there's nothing new in that. Similarly, you're cutting a toasting and slicing simultaneously bread. So as a pressing, it gets heated up. So toasting taking place and cutting taking place simultaneously. Again, this also arrangement rearrangements because with friction will get heated up anyway, and with heat it can create a burning. If you have the suitable materials in the knife, so this is also expected by somebody who is known in that branch of knowledge. So you cannot patent. So now you can see, in that case, nothing is patentable or what? Everything, some changes are there. No, it's not like that. Any unique inventive steps, once you know, capture that, then it will be easy. We'll see. Many patents are very simple. Paperclip, very simple method, is patentable. Why? Paperclip is 1900 only it started for Norway by John Valler. So then they wanted to keep papers together without making a holes in that, because previously made holes and tied. So paperclip is a mechanism of keeping paper together without making a hole. So it is inventive step at that time, because nobody had guessed that by turning a wire like this, it can clip them together and not go away, and can remove it, reuse it, and no holes required. So this is a very simple thing, but most important thing is the concept. So because of that, 400 paper clips are valued at $80 million. This is 1900 I'm talking. Now you imagine how much cost it will be. So it is patented, very successful patent. Now anyway, as it mentioned, patent 20 years over. So now it is public property. You don't have to pay, money to these patent agents. I'm sorry, the inventors or the patentees, because it's not public domain. Similar zipper, you all are using zippers for bags and cloths. So zipper is a very simple technology, how together and pulled. So it's inventive steps are there because nothing existing in this method before. So it's simple. It's a grand invention of one of the almost all of you use it in right now with zipper. Scotch tape, some this type cello tape you're using. So 1925 it started a company. They was used separate the different colors of the cars as they're painted. But soon it was refined to have a sticky glue all over its back and was used for painters, carpenters, eventually almost everyone. So 30 US patents worth of 97 billions have been contributed for this transparent tapes, cello tapes. So very simple things can be patentable. You just have to find out the inventive steps for that. I'll give this very interesting example. This is one case study which is very close to us. It is in Kerala. One group of researchers, they are carrying out some, they are biotechnologists. So they're doing some research, and that organization was, it is called Jawaharlal Nehru Tropical Botanical Garden and Research Institute, KCSTE. So in Kerala. So this organization, they are working. So that the investigator for that one lady, she thought that to collect some of the plants, she went to Western Ghat, because they're available somewhere in the interior Western Ghat. So she wanted to collect, for not for these studies, for some further studies, her own studies. So they went there, and then just 1 minute. So they went there. On the way, and they have to go interior, so they're taking help from some of the tribal people. So they requested them, can you please help us to go? Then the tribal people assisted, no problem, we'll go with them. They paid some money. On the way, she got very much tired, not able to walk properly. And then one of the tribal people told, madam, you just take these leaves, some leaves they given. And after she chewed the leaves, immediately she felt very active. And she was surprised how the leaf is so effective. Then she went and collected her plants. At the same time, she brought the leaf also, some of the leaf. And he found any other similar leaves available. That also she collected. Few more leaves which are helpful for that. Then she started studying on those leaves. Then she spent 3 to 4 years time and analyzing what is active ingredients in all the leaves. What is what making it so effective. Then she found out a certain combination. He combined them together in a particular formulation, which is now called Jeevani. It anti-stress and anti-fatigue agents. Now Jeevani is taken over by company. This particular plant from which Jeevani is prepared, this series of plants, they are available only in that Western Ghat area. And the tribal people called Kani tribe, they only used to stay, others didn't know about that. So they developed. So now this product, when she applied for patents, she got a patent because it is, it's although it's natural, but the particular combination in which she made it, the process she followed, and the product, both are unique, not obvious, and it is more effective than individual leaves. So, and it is much more effective than that. So this way, it got patent granted, and 96 the process patent filed process patent applications, the license is granted to them, and 7 years of $50,000 US. They sold initially for the initial selling royalty, and then for every product sale 2% royalty are given. So she got Kani Risk Trust. Now after this money, this organizations, the TGRI, they invest a part of that some to Kani, that village, what do you call that, tribal people, at a cooperative store for them, and invested this almost $12,500 and $450 for cultivating, restoring the land and cultivating the plant, because it's endemic plant, it's available only in there, nowhere else. So to cultivate that, they grown it. So now the money is invested for that, and they start evolving further. And this person, this whole group, they got more than 20 crore US dollars by now, just in few years. Just imagine what is potential for that natural plant. But they found out the particular combination and particular processes in its environment and they produced, and the purity and everything in such a way that is much more than what you expect of individual plants. And it industrial applications, novelty, inventive steps, complete disclosures, and patentability. So everything achieved. So you see what a successful patent. Then one company, Nutra Sciences Innovation Limited. So in New York, they based on herbal medicine company registered the name Jeevani at USPTO. India, we have got the United States Patent Trade Organizations. So in that USPTO, they have filed something that is infringement. Same another organization in Greater India. So now these people, what they did, not only India, they also got US patent, because they know they are developing country, they can also develop that products. Although this endemic plant available here only, but they can take ingredients from that and start doing that. So they suitable country also they extend their patent so that they will receive the royalty from those countries too. So there are two companies, Greater Earth. They also use an US-based company. See also Gibran Jolt 100,000. Some ingredients they used. So the infringement. So now they could stop them doing that. Now you understand? So it's not impossible. You just have to know how to do it. That's all. And that invention is very important. Another let's say technology side. Amazon one-click patent. So you see when you're all of you see Amazon for most of the things. Now when you go for Amazon, previously asked so many questions. Every time do you want that? Then you further details, give details about your what do you call this your account details, and then they'll ask OTP. So many processes are followed. Now everything is not cookies. You don't have to do anything. Just select it. Only one OTP asked. That's all. Everything comes over. Why they did that? Because they found many people the process involved in purchasing from cart. Once you leave something in cart, after that the process involved in purchasing that, by the time people change their mind. So people may not purchase, okay, why to spend so much money? So they don't want to give so much time for people to do that. So that's why they kept everything such a way, such secure way, so that just only thing required for you, just insert, you put the OTP. Because at least one, they stop that one, then anybody will cheat it. So if mobile is there with us, so that is the only thing they kept it, one step, one-click patent. So Amazon one-click. So everything will always stored. You just have to select which account you want, put OTP, that's it. Everything follows automatically. Within 15 seconds, product is booked. It was not that before. Now, all companies are following. Mostly, you may say, the other type of online business companies, all of them are now following Amazon one-click methods. All of them putting the same thing. Now, it's the technology, the sequence of methods, technology. So now they're paying money to the Amazon for their royalty. eBay and all of them are using the same thing. Flipkart, all are using the Amazon one-click method. Amazon only patented it. Instant purchase. So unique ID, they developed one unique ID number which is secret to individuals. That Amazon maintained that. So based on that, automatically all information, nobody can disclose it. I mean, can hack it, but they'll process it. So single mouse purchase. So 1999 patented. After that, file a lawsuit against Barney and Noble after 23 days of patent, because these people have developed something, but it was later than them. 23 days after, you see, just imagine, 23 days after, another company, Barney and Noble, exactly same method developed, but since Amazon got it, now they got infringement against that. See how important it is. The dating is very important. Just in 23 days, this country lost it. Now they have to pay money to Amazon to do that. So that's why the patent is very crucial. You have to do it as early as possible before it is taken by somebody. Somebody should not claim over it. So they are the procedures. Shopping cart method. I'm not going to details about that. We'll give you this recordings from that. You can go through more details about how rejected and all things. Then 2 years after they settled court. One interesting thing is that it need not, this inventive step doesn't mean that it's something very, very different, but the modification is not so obvious. That's the point. In fact, 90% of the patent is improvement only. Not that something very, very different from each other, but that improvement should not be obvious. That you have to see. That others should not have used the same method of improvement, similar type of improvement. Okay, that's almost 90% are like that. Only 10% are completely different from each other. Like the paper clip and all that. That time nothing was there. That nothing was there at the time. That type of things. But 90% are improvement. But you have to see inventive step has to be met. You might have seen recently the cricket which they use in night time. So they'll have a light here. The bell is a storm. They'll have bells. As soon as the ball hits the stumps, the bell comes out, and when bells comes out, the light glows. So this is the patent. They'll have such arrangement. As soon as the bell hits there, the light glows. So what is, you can say, what is rearrangement only? You connect together a circuit and light glows. How is the patent to get? In fact, these people are getting, I don't exactly, maybe some 80,000 rupees per each match for using their products. So I don't exactly know, but something in that range. They're using each game they're getting 80,000 rupees just for using technology. That much they're getting. So why should patent there? It looks very obvious. You break it to something disconnected, and then some circuit someone fit together, the light is glowing. People can see it. So why should patent? Because when you connect circuit, then only light glows. When breaking circuit, light doesn't glow. This is the inventive step. You break the circuit, then only light glows. When connect, the light not glowing. When they're together, not glowing. When you're breaking, glowing. So it's inversion. So that inversion concept was not done before. Circuit breaking, but while breaking only it is operating, glowing. Non-breaking, not glowing. Since that inventive stage is patentable. Is it clear? So this way is very important for us to have the uniqueness to find out what is patentable. Okay. So by this presentation we have covered about what are all aspects to consider about the patentability. Something is patentable if it has got novelty, new, it has usage, industrial usage. At the same time, inventive step very important. The steps are not obvious for a person skilled in that art, not an ordinary person. You're a pharmacy student. Somebody in expert in pharmacy, he should be able to see that it's not obvious. Then it's okay. Somebody in mechanical engineering, somebody in mechanical engineering also should be able to tell it's not obvious. Somebody in chemistry. So examiners for different disciplines, they have decided that it's not obvious. That is not the common sense doesn't say that. Not some polymer and some modification here and there is accomplished. Not like that. That is one inventive step. That is to accomplish. At the same time, it should also be best method. The specification should be complete. That it can be enabled. Anybody can follow that. And it should be non-patent. It should not be non-patentable. Why non-patentable? There are Section 3, Section 4 in the Patent Act. Section 3, we talked about different aspects that public morality should not be violated, not just mixture of each other, or not just a matter of some new properties to find it out, not a new method of horticulture, or maybe a new method for growing the plants. But GMO is allowed. And different plant varieties not allowed. But different methods of surgical things not allowed. But yes, device can be allowed. And so there are different things which can be some topography of these integrated circuit chips cannot be patented, and literature can be patented. So they cannot be patented. So in this category, it is not patentable. It should not be against public morality. All the things we discussed about that. So that is second. After that, you have to say most important is not new things. At the same time, method should not be obvious to others. We discussed many examples of how just cutting the toast and heating simultaneously, or putting the eye drops and a magnifying glass and cone and a funnel. This type of thing, some type of combination here and there cannot be patented. And we also discussed something very simple like safety pin, also something pin, clip, zip. All these things can be patentable because something new. We say how we can do now. It's not something very much new. No, slight modification possible. This was given example. How they modified in such a combination which is much better than expected from individual. That's patentable. That is what we should look for. Because 90% patents are actually that only from existing prior art. Okay, so this is how it should look for how to patent.